Hey everybody, it's Mark with United Real Estate, and I just want to spend some time going over the exclusive right to sell or represent buyer agreement. This is an NVAR form. This is one that we currently use right now. The form number is, if you see down here, K 1338. It is in zip forms, and it's pretty simple. Fill in the blanks. So this exclusive right to represent, when you talk about exclusive right, there's only one firm that we can that's going to represent people, and this is the form we're going to do this. So it's not going to be able to use this, they're going to sign this with our firm, then another firm, then someone else's. So the first thing to do is you put their name and actually first thing to do is put today's date. These don't get post dated; they're not pre-dated. You put today's date when you sign it. These should be filled out. What the printed terminology is upon substantive conversation. If somebody wants to know anything that they can find on the internet, the number of bedrooms, baths, how much is the house, how many houses in the neighborhood, that's not necessarily you're becoming an agent. But when you start giving opinion on properties, if somebody asks you what it's worth, then you start becoming an agent. So this is when you start using this form. Firm name, United Real Estate Premier. It says the broker is hereby granted the right to represent the buyer in acquisition of real property. And it also says the buyer is not a party to a buyer representation agreement with any other brokerage or firm. This is when you ask the conversation with people, have you spoke to anybody else? Are you have you talked to another firm? You got to have this conversation. My advice is to have this done in the office with your buyer consultation. That way, we're not filling this out on the hood of a truck or inside of a home or anything like that, because this is pretty important. And I see more people get upset because buyers didn't pay attention. And I think it's because agents didn't explain the form. You need to understand this form. So it says, also, as buyers disclose information about any properties that buyers previously visit to any new homes, communities, or resell open houses, or that buyer's been shown by another real estate associate. Got to ask those questions. All notice and information needs to be here. Fill out everything for the buyers, not just their zip code, not just the email, everything that they have. Some people may not have a home phone, that's fine. Broker information, that is all of our stuff. Our office number, your cell phone number, your email. Terms and termination. Pick a day. If you're having somebody that's just called in and wants to see one property or something like that, you can do it for one day or for one property, but pick a day, what it's going to be, and it's going to expire that evening. Now, it also says here, it says either party may terminate this agreement prior to the expiration date by notice to the other. So just by simple notice that they want to get out, or you want to get out, um, they can just send you a notice. That's all you have to do. And in the event buyer wishes to terminate this agreement prior to the expiration date without good cause, you can put a dollar figure in there. They're going to pay you $500. They're going to pay you $200. If it's going to be zero, put $0. This is maybe to protect you. Let's say they want to look at waterfront property and you've got to rent a boat. You might want some of your compensation back, but this is something that you have to talk to ahead of time. But this is without cause, without good cause. This is in section 5. It says broker's duties, and this is exactly what we're going to do. It says we're going to promote the interest of the buyer by performing to the terms of the brokerage agreement, seeking a price at a property at a price and terms acceptable to the buyer, presenting in a timely manner all written offers or counter offers. Now, this says written offers or counter offers. The National Association of Realtors Code of Ethics says all offers, which includes verbal offers. D, disclosing a buyer all material facts related to the property or concerning the transaction which they have actual knowledge. You find something out, let's say from the neighbor, you need to let them know. E, accounting in for a timely manner all money and property received which buyer may have an interest. Unless otherwise provided by law, buyer consents in writing to release the information. Broker shall maintain confidentiality of all financial information and all other matters identified as confidential by the broker. This is something you really want to highlight because at some point in time, you're going to have a conversation with your clients. You're going to know if they have funds, what kind of financial position, how soon they want to do. And this is something to point out that we're having a written agreement that I have to keep everything confidential. It says broker shall exercise ordinary care and comply with all applicable laws, regulations, treat all prospective sellers honestly and not knowing and giving them false information. Let's say, for example, if you're looking on a brochure and it says 0.3 acres, and then you pull up on a tax record and it's 0.35 or 0.28, as soon as you find that information out, you need to know, or you need to share that information. In addition, broker may show the same property to other buyers. So if you have a house, that you can show it to not only this client, but anybody else. Represent other buyers on the same or different properties. This says you can work for multiple people. Represent sellers relative to other properties, or provide assistance to seller or prospective seller by performing ministerial acts that are not inconsistent with broker's duties under this agreement. 6, this is what the buyer is going to do. So we're going to do something, and then we're going to ask the buyers to do something. The buyers shall work exclusively with broker during this agreement. So if they go out and sign another one of these with a different firm, they're in breach of this agreement. They'll pay broker directly or indirectly the compensation set forth below. Folks, remember this, directly or indirectly. In our market, the sellers usually pay the commission. But if there's no commission, the buyer will pay you directly. They will comply with reasonable requests of broker to supply any pertinent financial or personal data to fulfill the terms of this agreement. And D, be available during broker's regular working hours to view properties. I've been doing this since 2005. I'm not sure what regular working hours are, but if you don't work at 3 in the morning, you don't work at 3 in the morning. But this is the kind of conversation that you're going to have with your buyers at the buyer consultation when you sit them down in the office. It says buyers advised against and assumes responsibility for taking, posting, publishing, or displaying any photo or video recording of any property without first obtaining the seller's written prior consent. Hey, listen, if we're previewing properties and you have a client that's overseas or not in the market area, you need to make sure that you have it's okay to take pictures or videos of somebody else's home. Buyer hereby releases and hold harmless the broker's designated agent, sales associate, employees from any liability which may result therefrom. Buyer also acknowledges that the seller may have video and or recording system in the property, even if disclosure is not made. So, everybody's got Ring doorbells and things like that too. So this is kind of make sure that we have this conversation. The purpose, number 7, the buyer's retained broker to acquire the following type of property. Fill this out. It could be residential, investment, or whatever they're looking for, an apartment, vacation property, whatever it is. All right, compensation, retainer fee. I have never seen anybody do a retainer fee, but this might be in a case where, you do have to run a boat or you do have to do something different. If you're not going to charge a retainer fee, you put $0 in it, and what shall or shall not be subtracted by the compensation. So let's just say the broker compensation is $10,000, and you're going to have a retainer fee of $500. You can check the box shall or shall not be subtracted. Makes a difference between $10,500 or when you earn your commission of $9,500. All right, payment. The buyer shall pay compensation in the amount of MLS co-broke, not to be less than 2.5%. And the reason why we do not be less than 2.5% is because there are minimum standards that we want you to work for. Or let's say you go to for sale by owner, and if a sale by owner doesn't offer any compensation. Well, just because you're not getting paid doesn't mean you don't represent that client. If you're their agent, you're their agent thick or thin. What if in Bright MLS they have 1%? In the contract, you cannot negotiate compensation. So this is here to protect you in the brokerage. It says shall be compensated amount of X dollars to the broker if buyer enters into a contract to acquire real property during terms of this agreement and goes to settlement on that contract anytime thereafter. In most cases, seller pays brokerage fee, but in the event the seller does not pay any or all the amount, the buyer hereby agrees to pay any and all remaining broker fees due to the buyer broker. Brokers may retain any additional compensation offered by the seller or the seller's representative. That might be a bonus. Have an offer by March 1st and close by April 15th. Now, I've highlighted this in yellow. This is important. Broker's fee may also be earned due and payable by the buyer under either of the following circumstances. Within blank days, you pick it, 30 days, 60 days, whatever it is, after the expiration of the buyer's early termination of this agreement, buyer enters into a contract to acquire real property of the same discussed in the purpose paragraph. So if they go behind the sign and buy it, unless our agreement's expired and they sign it with another firm, or they enter into a forcible contract to acquire real property during terms of this agreement, and the buyer defaults. Let's say the buyer just says, "I'm not gonna buy it anymore." You still get paid. Yes, we got to sue them. Yes, we have to do all that. But this right here payment is really to help you understand how you're getting paid, and also how the clients, what their responsibilities are. If they're number 9, if they're in a relocation program, fill this information out. That'll be a conversation that you'll have prior to filling this out. Section 10. Oh yeah, down here on the bottom, you see where it says broker? I've circled all these. This is not you. This is the broker, because this agreement is between the buyer and the brokerage, not you. Even though as the principal broker, they'll never know your clients, but this is important because the agreement's between the buyer and the broker. It also talks about representation, about seller representation, buyer representation, designated and dual. You need to know this in and out. Most layman consumers out there, they don't understand the difference, but you need to do. So let's talk about designated representation. So you have your principal broker and you've got 2 people in the same firm. So let's just say somebody wants to see a house that's listed by agent A in our firm and you're agent B. If you don't check the second box, it says buyer consents to designated representative, and the buyer allows the broker to show properties owned by the seller, represented by this broker, through another designated rep. So if you don't check this box, you can't show any company listings. Doesn't mean you're necessarily going to follow through on this, but it says you can't. Dual. And I know dual representation is the fastest way to lose your license. This is my recommendation. Do the same thing. You check the box, consents to dual representation, because if you don't, you cannot show if you check the box, it means you can show your own listings. Doesn't mean that you're going to follow through and do dual, but for this paragraph right now, it talks about properties being shown. These are my recommendations and the reason why. If you choose not to show any company properties, check the box here. If you choose not to show your own listings, check the box there. Number 11 is compliance with fair housing laws. That's pretty self-explanatory. Attorney's fees. We never really want to talk about this, but I think it's something that hopefully we'll never get to this. It says, if any party breaches this agreement and the non-breaching party retains legal counsel to enforce its rights under, the non-breaching party shall be entitled to recover the breaching party. Listen, if I didn't do anything wrong and I get an attorney, I get the ability to recover it. Okay. I've also highlighted here too. It says, in any case, substantially prevailing party shall be entitled to recover any from the breaching parties. So if you're not in default and you're not doing anything wrong, you get to be compensated. Question right here to 13, buyer does or does not hold an active or inactive real estate license. Inactive doesn't matter in Virginia, any state, if you've had an inactive real estate license. Disclaimers. Hey folks, I know we're real estate agents. We are not attorneys, tax advisors, lenders, appraisers, surveyors, structural engineer, mold or air quality expert, home inspectors, or any other professional service advisor, unless you are. Now, I understand that you've been in houses and showing houses, you kind of know what's what, but don't say the floor is out because the joists are bad. I mean, it's obvious you can put a pencil on it, rolls across the floor that there's something that's not correct, but don't give advice. Stay in your lane. Let those professionals be those professionals. Also, in 14 disclosures is Megan's Law. If anybody wants to check it out, there is the website there. Wire fraud. We're still seeing more cases of wire fraud, and it talks about it. It says if buyer receives any electronic communication directing a transfer of funds to provide non-public personal information. Most title companies are not going to ask this. They're going to call you, or they're even faxing stuff again. So this is a disclosure. Beware wire fraud. Buyer service referrals. It says broker, one of the brokers that says sales associate may refer a service provider to assist buyer in his transactions. Front of our lobby, we've got home inspector cards, we've got warranty company cards, we've got termite cards, we've got. So this is saying it's not an endorsement, a guarantee, or warranty as to the quality, cost, and timeliness of the service to be provided. But I can tell you, once you give a referral to somebody, they're going to expect it to do well. So, but when you give referrals, make sure you give them a couple. So let the buyers choose. As it says here, buyers is advised independently to investigate all options for service providers. Listen, when you're sitting down filling this out, all these people want to do is go and see a house. Half the time they don't listen. But it's our responsibility to make sure that they do listen, and we understand this. Miscellaneous, because this agreement and exhibits and any addenda signed by the parties constitute an entire agreement between the parties and supersede any other written oral agreements between the parties. It can only be modified in writing when signed by both parties. The laws of Virginia shall govern the validity interpretation. Other provisions. I always get scared when people write stuff here. If you decide to write something there, the only thing, my best advice is talk to your broker. What are you going to do? Other provisions, maybe this thing is only good for 123 Main Street. If you only want to do it for one showing, if you just met somebody, they only want to do one property, but be careful when you do that too. This is in the bottom, but I think it's very important. It says buyers should consult with buyer agent before visiting any resale or new homes or contacting any real estate agents representing sellers to avoid the possibility of confusion over the brokerage relationship and misunderstandings about liability for compensation. Explain that to them. Before you talk to anybody else, let's have a conversation. Once again, the broker signs it here. The last page, page 5, buyer sign it, broker, sales manager, it's still not you. Put all your contact information down here, put all the firm information down there. That is pretty much our buyer broker agreement from NVAR. It's pretty simple, but it's really, really important for people to understand that. We also have an affiliated business arrangement disclosure. I think it might be a good time is when you're sitting down and have your buyer consultation to sign this. We're going to require it anyway, so you might as well have a conversation with it up front. It also it tells everything about who we are and what we do. It also talks about our title company. It doesn't have to, it's not saying we're necessarily using this, but it does says right here, it says may receive financial or other benefits as a result from this referral. If you need a copy of this, this is in Paperless Pipeline up in the Reference tab. And the other thing I would suggest you start working on now is this is our cover sheet. Fill out your name. Once again, this is located in Paperless Pipeline. You don't need it with a buyer agreement, but you might need to start getting some information. So if you're doing a contract, this is a good checklist for either you're writing a contract or receiving a contract. Make sure everything's there. So that's pretty much our buyer's agreements. It's pretty simple, pretty short. Gives you access to some checklists there. So if anybody has any questions or anything like that, would need some more information, this is the NVAR form. This is typically what we use. There is a VAR form. The last time I checked, I think there was 2 of them where it had exclusive right and non-exclusive right. I just don't use those forms, and we typically use it. So if anybody's got any questions, please reach out to me, and we hope you have a great day.